Today, DA Bragg's office consented to a 30-day delay in the start of the trial, but not because DA Bragg needs another month. The issue at hand is a new trove of records that were turned over by the feds, the U.S. Attorney's Office for the Southern District of New York. Specifically, 31,000 pages of records that the U.S. Attorney's Office just handed over to Bragg's office yesterday. Now, the DA specifically pins this newest delay on Trump, saying that Trump's legal team waited until just 2 months ago to request this massive trove of records from the U.S. Attorney's Office. And don't get me wrong, I am sure Trump's legal team is using every opportunity that exists to create delays in this case. It is what they do. But DA Bragg's office and the U.S. Attorney's Office know that. And one of the reasons this appears to be happening so late in the game is because the U.S. Attorney's Office requested repeated extensions that Trump's side consented to, according to DA Bragg. When the New York Times asked the U.S. Attorney's Office for comment on the delay, the office declined to respond. Joining me now are former FBI General Counsel Andrew Weissmann and NYU law professor Melissa Murray. Together, they are the authors of the brand new #1 Not Bad Guys, New York Times bestseller, The Trump Indictments, the Historic Charging Documents with Commentary. I first, Andrew, have to get your opinion on what's happened here in the New York hush money case, because on the outside, yes, I understand Trump's doing everything he can to delay, but what's going on here with the Department of Justice and their ability to get the DA and the defendants the documents they need in a timely fashion?
So self-inflicted wound, it doesn't look good, especially when we're about to get a decision on DA Fani Willis. Even if there's a decision not to disqualify her, the combination looks really poor. At the very least, this is a massive screw up on the part of the Southern District of New York prosecutors. I mean, really poor judgment not to have turned everything over a year ago when the DA's office asked for this information. If you've got inculpatory information, you should turn that over. If you've got exculpatory information that could help the defendant, you need to turn that over. So it was just a bad decision. I'm very focused not on this isn't going to be fatal to the case. There will be a trial. I'm very focused on what the information is. One thing to note is that the DA's submission today said that there's still more to come. So it's worth knowing they do not yet know, neither side, not the DA nor the defense knows exactly what the full scope is. I think that there could be information that's additional bad acts by Michael Cohen. Remember, Michael Cohen had pled guilty there, and the Southern District of New York prosecutors had publicly said at the plea hearing how much they distrusted him. They were very much fighting with our office, the special counsel's office. We were saying he should get credit. They were saying, no, he shouldn't. So there could be more information about that. There could be more information about Allen Weisselberg, because reading the tea leaves, it appears that Allen Weisselberg may have given information to them, may have even testified in the grand jury, but may have lied. And
he has already pled guilty to perjury. So.
Exactly. But there could be just more complications there. There also could be discussions about the theory of the case, of the federal campaign violation case. Why do I say that? Because if you remember, let's go back in the time machine to when Bill Barr was the Attorney General and was fighting with the acting U.S. Attorney, Audrey Strauss, saying that you should essentially get rid of the case, and she pushed back. So there could just be a whole mass of material, and that's what I'm sort of keeping my eye on, is sort of like, what is the information, and is it going to be something that's really meaningful? Exactly.
What I don't fundamentally understand is, and this is according to DA Bragg, he asked for a lot of this material last year and didn't get it, and then Trump asks for it in January, and so far 103,000, I think, is the count. Pages of documents have been turned over. I mean, what might possibly account for that?
Well, I think one thing you have to understand is, although all of these U.S. attorneys' offices are part of the Federal Department of Justice, they're prosecutorial offices working under the Department of Justice, they all enjoy a fair amount of autonomy. I mean, the Southern District of New York is also colloquially known as the Sovereign District of New York, and they take that sovereignty quite seriously. And so, yes, they don't always play well with other offices, state-level prosecutions. Like, they're doing their own thing quite a lot of the time. And this may be one of those situations. I think the thing to take from all of this is that This delay is not necessarily Alvin Bragg's fault. He definitely asked for this information a year ago. It wasn't forthcoming.
Yeah.
Now it's been disclosed, and apparently it is an avalanche of documents with more to come. And he's done the right thing, which is to concede that there should be a delay. He has pushed back on the defendant's request for a 90-day delay. He's requested a 30-day delay. That's sufficient time to go through these documents. But he has prioritized the rights of this defendant to have an opportunity to review these documents against him, review the documents that may have information about those who will be testifying against him, and present the most vigorous defense that he can. And that's exactly what he should be doing.
Well, yeah, and I think he's the one saying a 30-day delay would be fine by me. Like, I could do the final today, but I've got to also take it in a month when I've had time to prepare for it. What would account for, first of all, they were asked for this material last year. Then they're asked for it again in January. And then they're still saying, we need more time, we need more time, we need more time. And now it's the eve of the trial beginning effectively, and they're still not done giving documents. How does that process, does that seem plausible to you? How does the process work that it might be so greatly slowed?
Well, the one thing that I don't think happened is I don't think that Maine Justice was involved. It could be, but I just don't think that's the case. I agree with Melissa that U.S. Attorney's offices can, in a lot of circumstances, particularly in the Southern District of New York, just decide this on their own. That doesn't answer your question. That just sort of deals with, was Merrick Garland somehow part of this? And as we've discussed, I have my issues in terms of like the speed or lack thereof with respect to the Attorney General. But I don't think this is something I would immediately jump to him. It's hard to know how this could happen. I can tell you that my reaction, and friends who either had worked in the DA's office or worked in the U.S. Attorney's office all had the same reaction, which is not something I could say on air.
On this family program?
Yeah. And because it is either just a colossal blunder or just such a wrong view in terms of the judgment call here, in terms of what needs to be done. And the idea that it so clearly took Alvin Bragg by surprise meant this normally, at the very least, if you thought you had a huge cache of documents, you would call up the DA and say, you know what, we just found, or something just happened.
Just found 100,000
But it's clear
documents.
That didn't happen. This was, to me, it's pretty clear
that's
there's an
notable
intention.
too. I think that is notable too.
Yeah.
Donald Trump has been saying throughout all of these investigations and now these indictments that all of these various law enforcement officials are working in tandem. This is a collusive effort to selectively prosecute him. This makes clear that that is not the case. The Southern District of New York is not working with Alvin Bragg.
Wildly dysfunctional, not coordinating anything.
Yes.
Exactly. Complete dysfunction, but certainly not the collusion that he has implied.
Not a great defense, of course.
No, not the best defense.
They're so dysfunctional that they can't be colluding. Andrew, I got to push back a little bit. I'm not suggesting that Merrick Garland was the puppeteer of, dropping 100,000 pieces of paper in Alvin Bragg's lap and Donald Trump's lap. But I do think, this is a week where Robert Hur has gone to the Hill with this highly controversial report that the White House said, that I think a lot of folks, not even just Democrats, say was filled with just, out-of-school commentary about President Biden's mental acuity. The mere appointment of Robert Hur was a subject of debate. And then what he came up with seemed so, just political in nature and not to the support of the current occupant of the White House. It all serves to paint a picture of a Justice Department that seems sort of hopelessly concerned with how they're going to be perceived on the right.
So I agree with that. I'm trying to be sort of, judicious about taking each set of circumstances at the same time and looking at them to give them sort of fair weight. I agree with you with Rob Hur. I think that is a small p political decision. I think it was done to not have criticism. So you appoint someone who's a Republican. I think that is a massive mistake. I think it buys into the idea that special counsels can act out of principle. And if you point Rob Hur, that's what you get. So I think it is absolutely right to be critical of that decision. And I think it's important because I think it deals with sort of what would happen next. It's like an important milestone to say, you know what, this is what you get if you don't actually back your people in thinking that anybody, judges, prosecutors, jurors, witnesses will act, out of principle. I just think in this situation, I don't know what was motivating the Southern District of New York. I just don't think they would have coordinated this. I do think Merrick Garland, he may make wrong decisions, but I do not see him trying to slow this down by saying, do not turn inculpatory information over to prosecutors and exculpatory information. The prosecutor is going to want us to know both of those and will feel like he has an obligation to turn over both of those things to the defense.
But I think to Alex's point, though, Merrick Garland should have been writing all of these prosecutors in these U.S. attorneys' offices below him, like Seabiscuit, to get this done, right? I mean, like, so there is, I think, a failure of leadership here. I mean, just
right. If not
you
nefarious.
Are the department. Yeah, it doesn't have to be nefarious to be problematic. Like, he's in charge, and they report to him, like, this needed to be done. The defendant had a right to this information. Why did it take so long? And so, no, I agree that this may likely fall with the office, but the buck ultimately stops with Merrick Garland.
Yeah, I mean, I agree with that. I just think the chances that Merrick Garland knew, I mean, he may have been reading it the same way we did. And of course, you're right to be like, you know what, he runs the office. Ultimately, he's totally responsible. But, you know, at the U.S. Attorney's Office, the idea that this wouldn't be turned over, I'm pretty sure that to the extent that they didn't know at Main Justice, their reaction was probably the same as all of ours, which was, you've got to be kidding.
Yeah, you've got to be kidding is my refrain for this block of television tonight. Today, Vice President Kamala Harris did something no other vice president or president has ever done. She visited an abortion clinic. Harris traveled to a Planned Parenthood clinic in St. Paul, Minnesota, to highlight the stakes of the 2024 election. Even in a blue state like Minnesota, where Democrats control all the levers of state power and where reproductive freedoms are protected, a federal ban would nullify all of that. And the presumptive Republican nominee for president, whom Harris and Biden are running against, has expressed support for a nationwide ban. Democrats' bid to highlight the stakes here is only strengthened by what's happening elsewhere in the country. In Texas, basic access to contraception is now under attack. This week, a panel of appeals court judges upheld a Texas law requiring parental consent for minors to obtain contraception. And while this case might be about teens at present, it could also signal a fight ahead. At least one Supreme Court justice has already documented his desire to overturn the right to contraception among the population at large. Joining me now is Leah Littman, professor at the University of Michigan School of Law and one of the co-hosts of the great podcast Strict Scrutiny. And back with me is Melissa Murray, the other co-host, one of the other co-hosts, we're not going to leave Kate Shaw out, of Strict Scrutiny and NYU law professor. Leah, thank you for being here tonight. And Melissa, thank you for staying. Just don't ever leave. Leah, first, let's just talk about this Texas decision, right? Because I think there is some people are saying, oh, but this is just affirming a kind of general parental consent decree that exists in the state of Texas. But if you read it sort of in the real world, it sounds like they're coming for contraception here.
Absolutely, because you could have said the exact same thing when they began their war on abortion access, because initially, when they were attempting to restrict abortion, first they adopted laws that required parental consent for abortions, and then it was trying to enact laws that adopted additional restrictions on abortion providers, and then it was, well, how about adopting a law that requires spousal consent before obtaining abortions? And that was all part of a longer process that led to the court eventually overruling Roe versus Wade and ending the constitutional protections for abortion in Dobbs. And what we're seeing now is the beginning of the same thing happening for contraception, as Justice Thomas signaled in Dobbs that he wanted to happen more quickly than it seems like things are happening now.
It just feels like Clarence Thomas sends up a flare on like the crazy topic of his choice, and out there in the country, conservatives follow suit. I mean, do you think this is ultimately going to be, if not this case, a case about contraception is headed to the Supreme Court?
I think it is inevitable that contraception will go before the Supreme Court because, again, this isn't about simply forestalling abortion. I mean, if you wanted to end abortion, you would actually be in favor of expanding access to contraception to prevent unwanted pregnancies. It's not about abortion. It's not about preventing unwanted pregnancies. It's about controlling sexuality and, in particular, enforcing a set of gender roles on individuals like women who rely on abortion and birth control as means of controlling their reproductive capacity. And you're right. Justice Thomas is very much the intellectual genius behind this entire project. He often writes alone on the court. He did not get anyone to sign on to his concurrence in Dobbs. It doesn't matter because he has an army of former law clerks who who are now sitting federal judges in places like the Fifth Circuit who hear these flares as they go up, listen to what he's saying, read his opinions, and then put them out in their own courts as part of the law of their circuits. That's what we're seeing in the Fifth Circuit. We have seen it before in the Sixth Circuit. Justice Thomas has been shepherding this completely bogus narrative that abortion is linked to the eugenics movement and has been used as a tool to deracinate the African-American community. No one else signed on to his concurrence in an opinion saying that, but then it began appearing in lower courts opinions, and then it appeared in a footnote in Dobbs. So he is the sort of evil genius behind all of this. And when he's done for the night, he goes back to his office and strokes a hairless cat and prides himself on what he has done.
Talks about the end of bodily autonomy as we know it in this country. Leah, can you talk a little bit about Jonathan Mitchell, who is involved in this case, and Matthew Kacsmaryk, the judge whose name may be familiar to some viewers of this program because we talk about him a lot. He's done a great and inordinate amount of work in terms of furthering the conservative agenda through the courts.
Yeah, so he's a busy guy. He was the judge in the medication abortion case that the Supreme Court, the mifepristone case that the court is going to be hearing in a few weeks. He's a judge who effectively ordered a nationwide ban on medication abortion, one of the drugs used in the medication abortion protocol. He is also the judge in the Title X contraception case. He is also the judge where there was a multi-million-dollar lawsuit filed against Planned Parenthood in his court. And they are filing these cases before him, in particular his division, because they know, based on his track record, he was essentially appointed to do all of the things he's doing now, right? Making it more difficult to actually make medication abortion access available, now restricting access to contraception, and just outlining all of these theories that then some judges on the Fifth Circuit pick up on, and then they go up to the Supreme Court, and the Supreme Court is able to steadily move the law in a more conservative direction, even if they don't do everything that Judge Kacsmaryk does, even if they don't do everything that Jonathan Mitchell asks them to do, they are still steadily moving the law away from access to contraception, access to reproductive freedom, access to bodily autonomy. And so that is, again, what Judge Kacsmaryk was put on the bench to do, and that is what he is doing.
And Jonathan Mitchell is the guy that came up with the bounty hunter abortion law in Texas, right?
I mean, he is a busy guy. The bounty hunter abortion law in Texas, SB 8, which the Supreme Court allowed to go into effect well before Dobbs, essentially ending abortion access in the second largest state in the union before Dobbs did, a precursor of things to come. He was also the lawyer who argued the disqualification appeal before the United States Supreme Court for Donald Trump. And, we've talked about this on our podcast.
The 14th Amendment case.
We've talked about this endlessly on our podcast. We think he's auditioning to be our next attorney general.
Yeah, well, he has basically made statements, right, to the press indicating that he wants in the next Trump administration, the administration to begin enforcing the Comstock Act, a Victorian-era law from the 1870s that now more than 100 Republicans have signed onto a brief that they say allows them to ban medication abortion without actually having to pass a new law. This is a theory that Jonathan Mitchell says, let's not talk about until after the election.
Well, and he's great at these kind of end runs around what the law says, right?
He's great around these end runs, around majoritarian preferences, because they realize there is unlikely to be majoritarian support for a national ban on abortion. So even if they are able to get control of Congress and the presidency, there would be considerable pushback. But all they need to enforce the Comstock Act is a Republican president with a Department of Justice willing to prioritize this as an enforcement priority. And they're in business. They will resuscitate this zombie law, and they will begin enforcing it, preventing the shipment in interstate commerce of any article that might be used for abortion. And that includes long-acting forms of contraception that they term abortifacients.
Well, I mean, and this is coming as they're talking about litigating, well, they are litigating IVF, right?
Yes.
Once you have sort of allowed Christian nationalism to sort of infuse your party platform to the degree that all interference with contraception, which is where life begins, should be unlawful and is unethical, then that sort of dictates what your party priorities are in terms of policy, Leah.
Yes, no, they have opened the door to this, because once you start saying states have a legitimate interest in just treating fetuses, unviable fetuses, as potential human beings, then that doesn't end with abortion. It extends to contraception, it extends to IVF, it extends to all other manners of reproductive health care. And so that's happening with the Alabama Supreme Court decision. And honestly, this was happening even before Dobbs. Melissa mentioned treating contraception as abortifacients. The Supreme Court in Hobby Lobby versus Burwell essentially said that some employers were entitled to believe believe
Yep.
and then act on their belief that some forms of contraception were abortifacients and therefore did not have to offer that form of health insurance coverage to their employees. So the seeds have already been planted, and they are just waiting, again, for the next Republican president, knowing that the Republican Supreme Court will let them get away with basically anything, to test the limits of the law and try to bring a federal abortion ban to life without having to enact it into law.
That's why Kamala Harris was in Minnesota today. You could be in a blue state with Democrats controlling the state, have all the protections you think you need, but it matters who's sitting in the White House.